So picture this. You're just walking down the street, totally minding your own business. Meanwhile, unseen algorithms are actively scanning your face, matching it against literally billions of images, and logging your identity into some massive surveillance database. Sounds like a tech dystopia straight out of a sci-fi movie, right? Well, actually, that's our legal reality right now. Cops are actively scanning faces, and depending on how judges interpret our rights, legal experts are arguing it might actually be entirely illegal. Welcome to today's Explainer, where we're going to completely unpack this wild legal framework around police, artificial intelligence, and your fundamental right to privacy.
To kick things off, I've got a question for you, and it might sound a little weird at first. Is your face legally equivalent to your internet router? Or more specifically, your IP address? I know, it's a crazy comparison, but hold on to that thought, because as we're going to see, this exact question is literally at the bleeding edge of digital rights law today. It's the absolute key to the whole shebang.
All right, let's jump right into Section 1, the facial recognition problem, and the massive legislative gaps we're dealing with.
To really understand where we're at, we have to look back at how we got here. You probably remember the Clearview AI scandal. In January 2020, the New York Times exposed this startup that had just scraped billions of our photos from Facebook, Instagram, YouTube, you name it, to build this massive facial recognition empire. By March 2020, Canadian police, including the RCMP, were asked about it. First, they denied using it, but then they had to admit they'd actually been using it for months. It took until February 2021 for privacy commissioners to finally step in and rule that Clearview's billion-photo database was straight-up illegal because absolutely nobody consented to it.
But honestly, the damage was already done. 2,827. That is exactly how many warrantless searches the Toronto Police Service ran using Clearview AI in just under 4 months. Over 2,000 searches, identifying suspects, victims, witnesses, all without any judge signing off, no public notice, and absolutely zero oversight.
So Clearview got sanctioned, sure. But the really crucial point here is that police adoption of facial recognition technology, or FRT, didn't stop. It's actually still expanding. Right now, precincts in the Halton, York, and Peel regions are using internal forms of FRT. Even the Edmonton police began testing body-worn cameras with built-in facial recognition in December 2025. In theory, these cameras can spot any face within 4 meters and instantly compare it against a watch list. And the kicker? There is no explicit, comprehensive AI legislation in Canada to regulate any of this. It's basically the Wild West out there.
Which brings us to Section 2, bias and broken databases. Let's take a look at the actual flaws built into this AI tech.
Before we can figure out the law, we have to understand what the AI is actually doing behind the scenes. It's generating what's called a faceprint. See, it doesn't just look at a picture of you. It extracts deeply sensitive biometric personal info to map your specific facial features into a clinical searchable data point. Then, it compares your unique faceprint against vast databases to find a match. Sounds super objective and scientific, right? Well, not exactly.
Researchers have zeroed in on a massive issue here. Bias in, bias out. The reality is, facial recognition is significantly less accurate for women, the elderly, youth, and people of color. Why? Because these algorithms are mostly trained on the faces of adult white males. So civil rights groups are pointing out that relying on this heavily skewed technology leads directly to false matches and, ultimately, wrongful arrests.
The Canadian Civil Liberties Association frames it beautifully. They say using FRT is like police fingerprinting and DNA swabbing everyone in downtown Toronto during rush hour, then processing it in a broken database processor. I mean, what a powerful analogy, right? It perfectly captures just how reckless it is to deploy fundamentally flawed biometric systems on the general public.
And it gets worse when you get to court, because we run into huge evidence issues. AI relies on black box algorithms. That basically means the way the AI actually arrived at a match is kept a total secret. It's proprietary company tech, totally unknowable to you or me. Defense attorneys are arguing that if the police refuse to disclose exactly how a machine pointed the finger at you, how on earth can you fairly challenge that evidence? You literally can't. It's a direct threat to procedural fairness.
All right, let's move on to Section 3, your face versus your IP address and how this all impacts our charter rights.
The absolute foundational shield we have here is Section 8 of the Charter of Rights and Freedoms. It guarantees our right to be secure against unreasonable search and seizure. In plain English, the courts say this protects our reasonable expectation of privacy. So, generally speaking, if the state searches you without a judge's prior authorization, like a warrant, that search is assumed to be unreasonable. Now, let's bring it back to that internet router question from earlier. Check out the recent Supreme Court decision in RV Bikavets. The court ruled that police absolutely need a warrant to get your IP address. Why? Because an IP address links your anonymous online activity back to your actual identity. Now, just apply that exact same logic to your face. Facial recognition tracks and de-anonymizes you not just online, but in the real, physical world too. Your face is a way more permanent, deeply personal identifier than some IP address. So legal advocates are arguing that logic dictates police should 100% need a warrant to scan it.
Now, I know what some of you are thinking, but wait, my face is literally out in public. I have no expectation of privacy. But the Supreme Court has actually already addressed this reality of the modern age. In the R.V. Jones decision, they stated, Canadians are not required to become digital recluses to maintain some semblance of privacy in their lives. Just because we walk down the street or post a selfie online doesn't mean we just hand over our fundamental rights to arbitrary state surveillance.
And we really have to look at the alternative here. Without Section 8 acting as a gatekeeper, privacy advocates warn that absolutely nothing prevents the state from preemptively vacuuming up your image and running it continuously through massive surveillance databases without you ever knowing. It completely flips the balance of power between you and the state.
So where do we go from here? Section 4, Reclaiming Our Privacy and the Future of FRT.
Law enforcement definitely argues there's a trade-off here. They warn that requiring warrants for every facial recognition scan will put a massive strain on a court system that's already completely overburdened. On the flip side, though, civil liberties groups point to the very real erosion of our rights, arguing that unchecked facial recognition inevitably leads to racial profiling and wrongful arrests. For them, an administrative slowdown in the courts is a necessary, small price to pay to protect a free society.
So, here's the absolute main takeaway from our explainer today. While we are all waiting around for politicians to draft and actually pass proper AI legislation, digital rights advocates are looking to the courts to step up and fill the void. They're arguing that judges must act as our primary defense by classifying facial recognition as a search under Section 8. This would effectively force police to get a warrant before they ever process our highly sensitive biometric data.
The legal framework around this is actively being debated right now, and honestly, the stakes for our digital rights have never been higher. So I want to turn this over to you. What do you think? Should police be legally required to get a warrant before they scan your face? Does the benefit of catching a suspect outweigh the massive risk to your privacy? Drop your thoughts in the comments below. I'd love to hear your take. And if you enjoyed today's explainer, make sure you hit subscribe for more deep dives into the laws and technologies shaping our world. Thanks for hanging out and learning with me today, and I'll catch you in the next one.